Today's topic is about estate planning. 12 critical questions that you should know. Estate planning is a very critical element of your financial and life planning. It's all about how you're going to distribute what you worked a lifetime to create when you pass on. Whether you pass on to your children or to your heirs, you need to understand all the aspects and how this may affect you during your lifetime and after your lifetime. Welcome to Money in Motion. My name is Walt West, founder and CEO of the West Advisory Group, and we're here to teach you how to prevent money falling through the cracks during retirement. And remember, it's not what you make, it's what you keep. The first critical question is, do I need a will or do I need a trust? Two different types of planning strategies. A will is basically a document that you put together just determines where your stuff is going to go once you pass on. You typically name a legal representative, someone that's going to be your executor, if you will, that's going to make sure they're going to carry out how your assets are going to be distributed. It's a very simple document. It's very cost effective, but at a minimum, everyone should have a will. Second is a trust. A trust is somewhat of a more complex document that really takes a deeper dive into how you want your assets to be distributed, when you want those to be distributed, and who will receive your stuff after you pass. Oftentimes, a trust can be a living, breathing document that lives beyond your life. In other words, if you want to carry on a legacy, oftentimes a trust will allow you to do this. So the idea is determining, should you have a will or should you have a trust? Or maybe you should have both, but you need to ask questions about what might be best for you. The second critical question is beneficiary designations. Now, I will tell you folks that I meet with a lot of people day in and day out, and we always review beneficiaries. I can tell you from time and time again how people ignore or simply have not addressed their beneficiaries or simply have kept them up to date. Beneficiary designations are very powerful. In fact, if you had been really sophisticated in doing estate planning with trusts and all kind of legal documents, your beneficiary designation has more power than a trust and a will. Those things are ironclad. Oftentimes, they fall through the cracks. They don't get updated. You don't have the right beneficiaries listed. Life changes take effect. You must check, update your beneficiaries. So all things that have a beneficiary should be looked at on a regular basis to ensure they are up to date and you are designating those assets to the right heirs. The third critical question is, do I need a power of attorney? A power of attorney is simply giving someone the authorization to act on your behalf legally. And there's two types of power of attorneys. There's a medical power of attorney and there's a financial power of attorney. So in the event that you became incapacitated and were unable to make decisions on your own, the power of attorney or your representative of your power of attorney would step in to act on your behalf. They would act in a fiduciary capacity to make sure that things are being done right, whether it be to make medical decisions that are best served for you or making financial decisions. In other words, making sure the bills are being paid, making sure they have access to finances to help pay for things that you may need during the time of being incapacitated. These are very important documents, so at a minimum, you should definitely have power of attorneys established and up to date. And power of attorney should be reviewed every 3 to 5 years to ensure they are congruent with the current laws. The fourth critical question is, do I need a living will or a healthcare directive? Much like your power of attorney for medical purposes, your healthcare directive is designed so someone can make decisions about what should happen to you in the event that you became incapacitated. Should you be resuscitated or what might be the case from a medical perspective, your will or your living healthcare directive helps to determine or helps that person to make the right decision based on what your wishes are when something like that might happen to you. So having these documents in place can really take the guesswork and take the emotion out of making decisions on your behalf in the event that your health would deteriorate, something you must consider in the estate planning process. The fifth critical question is guardianship designations. So for those of you watching the video that have younger children and not at an adult age at this particular point in time, as you know, they cannot make decisions on their own behalf. Someone needs to make that decision for them. So it is very important to name a guardian in the event that something might happen to you, whether you became incapacitated or you simply passed on. Who will take care of your children? Who will make those decisions on your behalf? So you must ask the critical question is, do I need a guardian designation? How do I arrange that guardian designation to ensure my family is taken care of? A very big question and a very important question that you should understand. The sixth critical question is minimizing taxes. There's that word again, taxes. Every time I meet with a client and we talk about taxation, we talk about estate planning, the subject of taxes always surfaces to the top. Fortunately, by doing the proper estate planning, there are strategies and tactics and structures in which that you can create, whether it be through gifting strategies or trust arrangements that help you to minimize or potentially eliminate future taxes, whether it be inheritance taxes or probate fees or estate taxes. Fortunately, there are ways to address these through legal documentation to help minimize or even potentially eliminate that risk. The seventh critical question is the probate process. You should understand how the probate process works in your estate. The probate process is a process that's designed to help validate your will. It oftentimes is court supervised with the idea to make sure that your will gets executed properly. So a question you should understand through the probate process is how your assets will be impacted by the probate process. Individually owned assets typically will go through the probate process. Assets in which that you have a beneficiary designation or they are joint owned typically avoid and go around the probate process. So there are ways to avoid it, and oftentimes that might make sense. Some disadvantages of probate are, one is that it is a cost issue. Probate costs money in order to go through it. It also is a public forum. In other words, your information, your estate is more public in nature, and it is publicized. People have the opportunity to go to the court to see all the things in which that you have going on in your world. It also is a delayed process. Oftentimes could take months or years to complete the probate process, and oftentimes the assets in which that are going through probate are not accessible to your heirs for things like expenses, whether it be medical expenses or just other expenses that you might have financially. It does delay the ability to use those assets in the event that you're going through probate. So understanding the process, the pros and the cons is very important as you evaluate and build your estate plan. The eighth critical question is, or the things that you should consider, is reviewing and updating your plan. This is not a set it and forget it proposition, folks. This is something that you need to keep current. There's no doubt that we all have life changes over our lifetime, whether it be that we got married, maybe there was a divorce, maybe you got remarried, maybe you had another child, maybe you had other changes that happened in your life. All these potential things that could happen to you will affect your overall estate plan. It requires monitoring to ensure things are up to date, that are on track. In addition to your own personal changes, oftentimes there's tax law changes, there's legal changes that take place that would impact and affect your estate plan. You must review this, and again, it's not something you need to review every day, every week, every month, but you should review this at least on an annual basis or in the event that you have a life change, you should go back and evaluate your estate plan to make sure that everything is in good order. The 9th critical question is business succession planning. Now, this might not apply to everybody watching this video, but if you would happen to own a business of any size, it makes sense to make sure you have a succession plan in place. So what is a succession plan? In the event that you became incapacitated or passed on, who would take over that business? Or in the event that you were considering retiring and selling the business or transitioning the business to someone else, you must have a plan in place, a legal document in place that basically describes how things would play out in the event that you became incapacitated, you've had some sort of a disability, or you simply passed on. Especially if you have heirs, family, a spouse, how will those family members acquire your business in the event that you passed on? So having the proper legal documents in place is very important. You should not overlook this in the event that you own a business. This is a very important factor and oftentimes gets overlooked simply because of the busy day in which that you may have. It seems like more of a nuisance than something that's valid and something you should take into consideration until something happens. And you don't want to do this and wait for that time period, because then you're working in a reactive mode opposed to a proactive mode. So I encourage you to ensure that you have the proper business succession plan in place in the event that you're someone that owns a business of any size. The 10th critical question that should be asked is charitable giving. If you're charitably inclined and you want to give either money away or assets away while you're living, or especially when you pass on, what is the best way to do this? Interestingly enough, charitable giving does come with significant tax advantages. You should understand those. Having the proper documents in place in the event that you pass to ensure that the charity of your liking, of your desire, does get the proper amount of assets, the right type of assets, with the least amount of tax ramification to you and your family, is something you really should take into consideration. There are many do's and don'ts when it comes to charitable giving. First and foremost is the tax liability. Oftentimes when you leave money to a charity, it goes very tax efficiently to them, opposed to going to your family, which could potentially go tax inefficiently to them. So really understanding the dynamics behind leaving assets to the charity and what type of assets is a crucial element, and you should ask many questions about how to best structure a charitable plan as you build your overall estate plan. So the 11th critical question is digital assets. Now this is something that's new and up and coming. So you're hearing a lot more about digital assets, whether it be currency, cryptocurrency, but there's so many different things that are being done digitally that it was intellectual property or property in which you have that should be identified in your estate plan. In other words, in the event something would happen to you, what happens with those digital assets? You need to take a deep dive and have a conversation about the assets in which that you own digitally and how they would be handled in the event, again, you became incapacitated or you simply passed on. How would they pass on to the next generation or to your heirs? The 12th and final critical question is obtaining legal and financial advice. And this is always a question that's raised when I talk to people, and that is, should I do this on my own or should I hire legal representation or a professional to help me build this particular plan? I always caution and I weigh to hiring a professional. There are so many nuances and potential for things falling through the cracks when you do this on your own. If you're not a professional and you understand all the nuances when it comes to estate planning, and you simply do this online or you do this on your own, there is this potential for things to fall through the cracks. So I would weigh on the on caution that hiring a professional would put you in a much better position, because things, I will tell you, can be contested. In the event something would happen to you that you would pass on, and now that you have these legal documents that you created on your own, they could be contested. One of your heirs, those that are supposedly to receive your assets, they could contest how these assets are being laid out to the next generation. And if you're not here to defend what you put together, it makes it very complex. So having a professional build these plans on your behalf really helps offset that liability of contestability. So I would urge reaching out to a professional to help you build a solid, sound plan for your estate plan, to give you the confidence, the comfort, and the clarity that things are being addressed exactly the way they need to be addressed. So I know there was a lot packed into that estate planning process and all those 12 critical questions that you should ask. This was not a video to help you solve all these problems. This was a video to help you raise questions that you can ask better questions to your family, to your professionals, to your estate planner, to your financial planner, whoever that might be, so you're in a better position to protect what you worked a lifetime to create. Again, thanks for tuning in here to this video, and hope to see you next time.